The Federal Immigration and Nationality Act, INA, of 1952 prohibits employers from discriminating against people based on their real or perceived citizenship or immigration status. However, the Federal Immigration Reform and Control Act, IRCA, of 1986 requires you as an employer to verify that all your workers are eligible to work in the U.S. What can you do to inquire about citizenship status when making hiring decisions? Stay tuned to learn the answer. When you can ask. The Immigration Reform and Control Act requires you to verify your employees' eligibility status, even those you know to be U.S. citizens. However, the same act prohibits you from asking people to prove their citizenship or work status before offering them employment. What this means is that you can only verify a person's eligibility status after you've made the decision to hire them. However, you can inform potential candidates that you plan on verifying their authorization status upon selection. The Equal Employment Opportunity Commission, EEOC, recommends adding the statement on employment applications to ensure compliance. Keep in mind that your employment application forms should not garner a response that would indicate an applicant's nation of origin or employment authorization status. Although you're not explicably forbidden from asking these questions, they could be used as evidence of intent to discriminate. Ask, but carefully. But there's a way to determine work authorization beforehand. You have to ask each applicant the same question in the same way. To avoid bias, it's best to ask this question prior to the interview. Remember to mind your language. Any hint of bias could make you liable to discrimination charges and investigations by the Department of Justice's Office of Special Counsel, OSC. Note, the question must be phrased solely to determine a candidate's ability to work legally in the U.S. It bears repeating, you should not ask about the candidate's immigration status or citizenship. Here's one way you can phrase this question. Are you legally authorized to work in the United States for blank company? Yes or no? Or you can ask, do you now or will you later on require sponsorship for employment visa status to legally work for our company in the United States? Yes or no? Such questions are permissible because they are designed to determine potential hires' eligibility status or whether you would have to sponsor the applicant for which you are under no legal obligation to do so. You'll notice that the protection does not extend to temporary visa workers. As a result, the decision not to hire someone based on their need for visa sponsorship is not actionable under the INA's anti-discrimination provisions. Then again, that is tantamount to wading through murky waters because you would have to prove that this was the sole reason you couldn't hire that particular individual. And you cannot refuse to hire someone because their visa will expire in the future. Employment authorization status. As an employer, it's your responsibility to maintain a legal workforce. By law, you are required to verify the identity and employment eligibility of all your employees. From the minute you bring a new hire on board, you have 3 days to fill out Form I-9, Employment Eligibility Verification. Always ensure you use the latest form as the I-9 is periodically updated by the U.S. Citizenship and Immigration Services. It's illegal to discriminate against a potential hire or employee based on national origin, citizenship, or immigration status. Although it's your duty as an employer to use the I-9 to verify a person's work eligibility, you must be careful not to invade their right to privacy. You must understand that it's never appropriate to ask about citizenship. You can only ask about work eligibility, and even then, you must exercise caution so as to stay compliant and avoid legal repercussions down the line. Are you looking to advance your IT career? Nexus IT Group can help. Contact us today to learn more.